Our second presentation today is on corporate structure, financing, and related regulatory considerations in the cannabis industry, which is what we're talking about. This is sponsored by Vicente Sederberg, and I'd like to introduce Adam Fine, who's the managing partner of their Boston office. Adam is a leading voice on cannabis law and policy in the Commonwealth. He served as a consultant to the Massachusetts Special Senate Committee on Marijuana and as a member of the drafting committee for Question 4, which was the ballot initiative that legalized marijuana here in Massachusetts. He has testified before numerous municipal and regulatory bodies regarding marijuana policy and compliance, chaired multiple cannabis-related CLEs like this, and represents Massachusetts cannabis businesses and prospective licensees on corporate licensing and regulatory matters. And so I'm going to turn the program over to Adam.
Thank you. Welcome, everybody. So I'm pleased to be here. I always enjoy talking to lawyers in the cannabis space, and I know there's a lot of programs, and it's almost kind of a saturated CLE, well, not so much CLE, but in terms of just programs relating to cannabis. But the lawyer ones are typically the best ones in my mind because, and I also, I hope I don't offend my panelist Mitzi, but I think lawyers are probably the most important consultant in the cannabis space. CPAs are up there, but you know, we're called upon to kind of really answer some of the really difficult questions in the space. And there's a heavy burden on us as practitioners. I know not everyone here are lawyers, so I'm just kind of speaking to lawyers. To really keep current, understand what's going on, because if you don't, you're just really gonna fall behind, and it's easy to fall behind because cannabis are changing kind of daily. So excited about this panel. We got a superstar panel. It's a little weird me standing back here behind them, so maybe I'll start walking around. But I'm gonna let the panelists introduce themselves. I just want to say we have two from our firm. You know, we sponsored, so we got to stack it a little bit. We got a representative, or partner from Foley Hoag, who's a really leading firm in the space as well. And then I'm sure many of you probably know Mitzi from Citrin Cooperman on the kind of tax accounting side. So with that, I'm going to turn it over to the panelists to each take a minute or two just to introduce yourselves, give a little bit of your background, and then we'll kind of roll into questions. Actually, before I do that, I like to do this at the beginning of panels. Does anyone here have like a hot, we're going to leave questions at the end, but are there like general topics, because we went really broad today, because we wanted to tailor to the audience. Are there general topics or just issues that you just want to have the answer to before we end today? Because I want to make sure our panelists hit those questions. So if anyone has that, please raise their hand. If not, we'll kind of roll right in. Anybody? Okay, good. So we'll roll in, and I'll kind of stick with the plan for today, the topics that I was going to cover, but we'll take questions at the end, and we can take questions during as well. We're pretty loose here. So with that, I'm going to start, I guess, Ilya, we'll start with you. Ilya Ross, he's with our firm, and Ilya, maybe you can just give a little bit of your background and how you fit into the space.
Sure. Can everyone hear me? So thank you for having me. Very happy to be here. My name is Ilya Ross. I am counsel at Vicente Sederberg. I work out of both our Los Angeles and Boston office. You know, it's a coast-to-coast growing industry. My background, I'm actually a big law refugee. I worked at Greenberg Traurig and another big law firm in New York. My background is primarily securities and capital markets work, both on the SEC compliance 34 Act side, as well as offering work, 3033 Act, you know, IPOs, follow-ons, private placements. You know, as a civil libertarian, I'm a true believer in this industry, and I was very excited to join Vicente Sederberg a little over a year ago, and to be part of, you know, this growing ecosystem, and yeah, just to build a new industry. So happy to be here and excited to speak with you all.
Hey everyone, my name is Elliot Choi. I'm corporate counsel of Vicente Sederberg. I work out of our New York office, which we opened up earlier this year. Kind of like Ilya, I'm a big law refugee. I've been practicing corporate transactional work in New York for about a decade now. Started off at Skadden doing mergers and acquisitions, debt financings, and then I moved to Friedman Kaplan doing more of the same, but also kind of expanding into kind of acting as de facto GC for a bunch of our clients, all sorts of industries from like waste management to clinical laboratory testing. And so, you know, that gave me kind of a broad range of matters that, all companies of all sizes deal with. And so, earlier this year, I pivoted over to Vicente, and in kind of anticipation of hopefully New York and New Jersey legalizing adult use. Unfortunately, it didn't happen, but at least we kind of got our footprint in New York and New Jersey. And so, hopefully in the next year or two, that market will open up and we'll be able to expand there. And thank you for having me.
So I'm the lone CPA in the group, apparently. So my name is Mitzi Hollenbeck. I am a partner at Citron Cooperman. We are the 23rd largest CPA firm in the United States. We have offices all up and down the East Coast, one in LA. I work primarily out of our Providence, Rhode Island, and our Braintree, Massachusetts offices. And I am the I'm the founder and co-practice leader of the Cannabis Advisory Services practice at Citron Cooperman. So we deal with all different clients in different aspects, both those who are investing into the cannabis space in terms of maybe due diligence work and or kind of review of slide decks and things like that for our high net worth individuals, as well as operators, dispensaries, cultivators, both internationally and domestically in the United States. And we kind of handle the gamut of tax, accounting, and business consulting related to those clients.
Hi, I'm Patrick Connolly. I'm a partner at Foley Hoag. I've been at the firm about 10 years, practicing corporate law focused on venture capital and emerging companies, some M&A, general commercial things, licenses. And I've been a member of the cannabis practice for the last couple of years, which developed out of our regulatory group. It was a natural extension of their work that once they started to help folks get licenses and apply for licenses, those folks started to need advice in regard to their corporate finance transactions. So it's been a pretty busy area, as you can imagine, for the last couple of years. It's been interesting, and it's expanding from the corporate finance side and the founder formative side to include M&A and licensing and all the rest. So glad to be here.
Great. Thank you, panelists. So I'm going to start off with it might be a pedestrian question, but I'm going to ask it because I think it's a question that I'm not sure I still know the answer to. And I'd love to hear the perspectives on this panel. But it's a question it's going to come up in your practice if you're in this space and you're looking at companies, especially when they're starting out. So the question is LLC or corporation, and be as specific as you can, because I'm really interested in each kind of factor, or as many factors as you can. And this is a question that from a regulatory standpoint, it's somewhat easy for us to answer. And also, if you talk about the state of incorporation, how important is Delaware, for example? How important is a cannabis legal state? And maybe I'll just leave it. I'll start it off with whoever wants to take that question.
Perfect. All right. So typically what happens, I find that I get called in to clients who are asking this question all the time. And what I tell them is that I am not an attorney. We can't advise on structure, but we can advise on the tax impacts of your structure. So oftentimes what I do is I end up asking them what their ultimate goal is. Are they looking for outside investors? Who's going to own this company? Because a lot of times what you don't want to do, or what some of the investors don't want, is they don't want pass-through income, which is, of course, what happens when you have an LLC in this instance. You're going to have a K-1 that's going to have pass-through cannabis income. It potentially will subject their 1040 under examination by the IRS to their personal return being audited and subject to 280E. So that's an area of concern for a lot of people who are investing into the cannabis space. A secondary implication just related to the tax impacts in the cannabis space is that these companies are subject to a code section called 280E, which means that they're not allowed to deduct any ordinary and necessary business expenses or have any credits with regard to operating and trafficking in a controlled substance. So for example, I always give the dispensary example, where if you're a dispensary, anybody who's ringing your cash register, the salaries of those people, your rent, your utilities costs, any marketing expenses that you have are not deductible expenses. All you get in the cannabis industry is an adjustment to income, which is called cost of goods sold. So if you're buying product at 50% margin, you sell $1 million worth of product, you're going to be taxed on $500,000, regardless of the fact if it costs you $750,000 in rent, salaries, and everything else, and you lost $250,000 in that year, you're actually going to be taxed on $500,000. So if I'm an investor and this company has absolutely no money by which it's going to pay me a distribution to cover my taxes on my K-1, then why would I want to be in that industry? I'm going to get taxed on $500,000, and I'm going to have what otherwise would be somewhat considered phantom taxable income although it's not, on my personal tax return. So a corporate structure allows for that to be taxed at the corporate entity. It also can allow for better cash flow in terms of not having to pay out, tax distributions if your LLC operating agreement dictates that. I mean, there's a whole host of things, so I'm trying to be as succinct as possible, but I could go on this topic for probably 3 hours, so I'm gonna just stop.
Yeah, so let me, it's funny that Mitzi said her first comment to clients is, well, I'm not a lawyer, so I can't answer that directly, because we say the same thing. We say we're not CPAs, we can't advise on the tax issues. But what we can advise on in terms of the structuring is similar to what Mitzi said. What is your end goal? What is your, exit? What are you thinking in terms of how you want to structure this business? As one example of the many regulatory hurdles that coincide with this question and other corporate questions, can you sell a license, right? Can you, as an entity, you have a cannabis retail license, can you sell it to another entity? Some states allow you to do that, some states do not. For states that do not allow you to do that, you're left with only the ability to sell your equity, meaning, your entire entity. Now, do you have real estate under the umbrella of that entity? Is that going to come along with the sale? Do you want that real estate housed separately so you could lease it out? If the latter, you would want the real estate in one structure. Presumably an LLC, given the lack of similar 280E concerns for the real estate, and also some of the depreciation value and benefit of having that taxed at the LLC level. And then you could have your licensed entity as a C-Corp, right? And we do, look, for the most part, we do advise having a C-Corp at some level of the corporate structure because of 280E. The question is, where in the corporate structure is that going to fall? Is it going to be at the holdco level, right, at the entity that holds all of the various entities? Is it just going to be kind of above the actual operating licensed entity? So that's one consideration. Like Mitzi said, we can talk for hours about this. Another one from just a pure legal corporate governance standpoint is complexity, right? An LLC is a much simpler structure from a documentation standpoint. You file your articles of formation. You should have an operating agreement between the members if you have, multiple owners that sets the various rights and obligations between, the members amongst themselves. But you don't have to. I mean, you literally can just file formation documents and not have to do anything else from a pure governance standpoint. That's not the case with C-Corps. You need your certificate of incorporation, you need your bylaws, you need a board of directors, you need to follow a number of corporate formalities to avail yourselves of the protections of being a C-Corp. I'll stop here in case, my other panelists have other thoughts on this.
Well, I'll tackle kind of the state choice part of the question. So I think a lot of us are used to forming entities in Delaware, whether they be corps or LLCs. I'm sure we all have our form articles we just pull up, change the name, change whatever the shares and par value are. But one rabbit hole I went down early in my time at Vicente is that, we look at in Delaware in particular, you have the purpose clause, and I'm sure we all use a generic one. You can form this business for any lawful purpose. Now, if you think about that, in Delaware, there's adult use isn't legalized down there. And so, if you're forming a Delaware entity and you're putting the purpose clause is for, any lawful purpose, well, I mean, have you correctly formed an entity in Delaware? I mean, it's an open question. I mean, there are analogies you can make to casinos and sports betting companies that are formed in Delaware that have operated and without problems. But and there's a story out there that somebody tried to incorporate Marijuana Inc. in Delaware, and that got rejected. And I know from conversations with the Secretary of State down there that if you do in fact have a reference to marijuana or cannabis in your entity name, it'll go through another level of review down there. So they won't automatically just have your certificate filed. So it's a question you need to consider. And so we know that most of our clients typically would form the entity in the state where they intend to operate. That just seems to be more of an optical concern. It doesn't really seem to be required by any of the regs that it be that way.
Except Massachusetts, it is a requirement.
Also, then, speaking of Massachusetts, as I'm sure you all know, that the initial regulatory regime required the entities be nonprofits here, and they recently changed that, and so we've been working to change these entities from nonprofit to profits. And we've been typically relying on the general purpose clause, since, it's adult use is legalized here. But we actually got some pushback recently from the Secretary of the Commonwealth that they wanted the purpose clause to be more limited in the first instance, to actually refer to the fact that these companies, these entities are trying to get a final registration in the Commonwealth, which it was an interesting kind of feedback that we got because, again, it's lawful in Massachusetts, but, the Secretary, they saw the purpose clause, they wanted it to just be more narrowly tailored, and so that's kind of how we're operating. So, even things like entity formation in industry aren't necessarily so straightforward as you're used to kind of in other industries.
Yeah, I would say that I've formed a lot of Delaware corporations as holdcos for licensees. I think there's a distinction between the state in which the license applicant needs to be formed. That's in Massachusetts. That's obviously Massachusetts. We have gotten comfortable forming Delaware holdcos as corporations so that it makes the capital raising process a little easier. One thing to consider, I agree that forming an LLC and getting an LLC in place is pretty simple, but one thing to consider is as you're running an operating company, it's always a little bit more complicated to run an operating LLC than it is to run an operating corporation, in large part due to equity compensation. If you're any small startup company, whether it's a tech or biotech company or a cannabis company in this case, most likely is going to be cash constrained, and in lieu of paying market wages to early contributors, the guys, in our case, the men and women who are growing the product and, who are the bud tenders, to use the West Coast parlance, or the dispensary agents, to use the East Coast parlance, those folks might be giving up cash compensation because they're getting a piece of the equity of the company. Doing that in an LLC is an absolute nightmare. People don't understand it. If you give LLC interest to a rank and file employee, they get something that's, they're known as profits interest. It's a term of tax art. Nobody understands them. Mitzi, I'm sure, understands them. We've spent a long time talking about them.
Not going to do 3 hours on profits and
We're on the same page here.
No, I don't want to interrupt, but I want to come off of I want to hit the profits interest point, but I wanted to let you finish, Patrick.
Oh, yeah, so if you have a nascent cannabis company and it's a few founders and you form it as an LLC, we're seeing a lot of conversions from LLCs to CCorps or contributing the LLC interests up into a parent CCorp. Leaving aside the question of jurisdiction formation, I think you have to deal with that on a case-by-case basis. But to Mitzi's earliest point, you always want a CCorp blocker somewhere in the structure, and where that's going to sit is just that's a question. And then, so yeah.
Yeah, no, so panels real quick. You just, gun to your head. Licensed entity being held there, CCorp or LLC, in Mass, if you got a default.
Or LLC held by some other parent entity.
I would never answer that question.
I'd go with the CCorp.
CCorp.
Right. Thank you. So
Licensee?
Yeah, I mean the only other issues to consider too, when you look at 1202 stock, right? So you have the option. Again, there's all these
Mitzi, you don't get to say that because you didn't answer the question.
No, I didn't. I know. But what I mean is, I think every set of circumstances is different and unique, and that's why I always make sure that we kind of go in as a team between the CPA and the attorney, that we are talking. And your professional services providers really kind of need to be talking to each other, because you'll have these conversations and really find out what the ultimate end goal is. If it's a state where you want to sell your license and you put it into a CCorp, well, now you subject yourself to double taxation upon the sale of that asset out of that CCorp, versus if you're selling the stock where you're actually not subjecting yourself to double taxation. So there's a lot of different reasons, and I think the answer is that there really is no clear-cut answer. So yeah, I totally dodged the question. But most of the time I just make sure that, we're talking with the attorneys, that the client has both of us in the room or on the phone to make sure that they're making the best choice.
And to go to Ilya's earlier point, you can, some of the great benefits of an LLC where, you have a partnership agreement, an operating agreement, where you can put all sorts of novel terms in and all sorts of different, bells and whistles that you might not have available in a C Corp. You can take that LLC and check the box and be, elect to be taxed as a corporation and get the tax benefits of that blocking entity.
And I will just jump in and say I would hardly ever recommend an S-corp, and there's a number of reasons for that, including a tax court case that happened out in Colorado where there was an owner-operator who, of course, did not give themselves compensation on a W-2 on their S-corp, and the IRS came in, did an investigation, found that you didn't pay yourself reasonable compensation, so they imputed reasonable compensation on a W-2, so the S-corp sole shareholder ended up with a W-2 for $60,000 and then also had to pay double taxation because their salary was not deductible. So therefore, S-corps typically are a very bad idea in this industry.
And just like one more additional consideration I'll add, again, not a tax lawyer or CPA, but my understanding is that if you're an LLC and you have multiple members that are individuals, they could be subject to a tax audit risk if the LLC gets audited. So the individual members would also be subject to audits, and I don't think any of us want to go through a tax audit. So it's another consideration to take into account.
All right, good. So no, that was very helpful. I think we'll move on. I did want to go into kind of if you're representing a minority like holder of an LLC, because one of the things I've seen is that can be really complicated when you're talking about some of these operating agreements. So to kind of pay really close attention to all those nuances in the operating agreements, which in the C-corp I think it can be much more straightforward. But we've seen a fair amount of litigation in the space over these operating agreements, and actually claims against attorneys. Fortunately, not attorneys in our firm, but we've seen malpractice claims where attorneys are representing a minority investor and an LLC and really just didn't understand the profits interest implications or the tax implications. So just be really careful. That's my practice point on the LLC side. I don't know if our panelists agree on that, but I think it adds a level of complexity if you're getting really creative on your LLC agreements. So I want to talk about a question that comes up commonly, and all of us are going to see that. And if there's operators or non-lawyers in the room, this might be more germane to you, which is what are we talking about? How do you raise capital? Where is the capital coming from? And what about these traditional structures? We talk about safes and convertible notes. Is there an optimal path? Again, I want to be really as helpful as we can to folks out there. But some people say safes are good. Some people say they're bad. Convertible notes. I'd love to hear the panel. So I'll start with you, Patrick, because I know you work with a lot of emerging companies, maybe in cannabis and not cannabis.
Right. No, I think, in my practice, I try to apply the experience that I have helping biotech and life sciences and tech companies raise private capital to the cannabis industry. And it's not always a perfect fit, but I think we're sort of moving towards that level of sophistication among the operators and the investors to where, 2 years ago, it was very frequent where someone would come to you with some proposed deal structure that was just bananas. We're going to raise $150,000 and here's 3 pages of terms. And we said, well, this looks good, but it's going to cost $150,000 of legal fees to implement, right? So, to the question of what are people buying? Are they buying safes? Are they buying convertibles? Are they buying equity? The answer is yes. One thing about safes and convertibles, you really can't sell those. You can't fundraise using that means if you're an LLC. You either need to have checked the box or you need to be a corporation. That's right, Mitzi?
I think you're right.
Yeah. Otherwise, the problem is
not my area of expertise.
If you're an LLC, to the point that was made earlier, if you're an LLC and you take on indebtedness, convertible debt, and then that debt converts, that income is imputed to your members. So if you raise $1 million under a convertible instrument, then the instrument converts into equity. The company no longer has that $1 million of debt. That benefit flows through to the members as $1 million of income, and that's a really bad result. I am starting to see operators raising money by way of convertibles. I think the question of safes, I don't know if everyone here is familiar with what a safe is, so I'll just say it. It's a simple agreement for future equity. That is just a cute little acronym that I think Wilson Sonsini came up with. Did Wilson Sonsini invent the safe? Does that sound right?
Yeah.
Yeah. So it's not simple. They should have called it something else. But it's basically, I think the best explanation that I've heard for it is that it's a prepaid warrant. The investor says, I'll give you $100,000 now in exchange for $100,000 of equity in your next equity round at either a discount or at a capped valuation. It's not really debt because I'm not going to charge you interest and there's no maturity date, but it is an obligation on the part of the company to give me something in the future once you go and raise that equity round. So accountants really, and again, I'll defer to Mitzi on this, but in my experience a few years ago, accountants really hated these because they didn't know what they were. Are they debt? Are they equity? Nobody knew. I think at this point, everyone's sort of reached, people hold their noses and say, okay, it's sort of like a prepaid warrant, and if the money's on the table, let's take the money under the safe. The risk is really on the investor's side, right, because they don't have some of the protections that a debt instrument might afford them. So those are out there. Convertible notes are out there. I'm sure you're all aware of what convertible notes are. And we're also seeing a lot of seed equity rounds where folks are coming in and saying, well, we think your company is worth X and I'll pay you Y in exchange for a percentage of your company. And I'll defer to the other panelists. I think that the discussion of valuation, the types of valuations we're seeing is interesting, but I don't want to go on and on. But the last point I'll make is that we're also seeing a lot of creative joint ventures where we are seeing these sort of wacky structures where strategic investors, folks who have multi-state operations out in Nevada or California or wherever are coming into Massachusetts and saying, I'll contribute some resources, which might include cash, equipment, know-how and training, brands, et cetera, and put those resources into an LLC. You'll put your license and some other stuff into an LLC, and then we'll all make a lot of money together. So that's another approach to corporate finance that we're seeing.
And I think I'm only going to say a couple things about that entire, overview, which is fantastic about, what's happening in the finance side of it all, is again, every single piece that Patrick talked about has pretty much a different tax implication. So that's really when, we bring in, some of our corporate tax finance specialists to really deal with some of those issues, because things like debt to equity conversions, and depending upon when people are entering in, maybe they are, getting 20% stake of equity, for $20 million. So now all of a sudden you have third-party evidence of what the valuation of that company happens to be, and then you have a conversion. So there's a lot of different issues where people are having income that's being attributed to them based upon these valuations, and it's important to kind of figure out exactly how they want to finance it and then what those tax impacts are going to be.
So one really kind of related topic I want to address here is that the investors, whether it be a safe, convertible note, I think they need to be clear up front that, that they'd be kind of deemed an owner of a license holding entity, and depending on whatever state you're in, they may need to be disclosed to the regulators. They might have to fill out, personal history forms. They might have to go under fingerprinting, criminal background checks. And I think this is something that gets lost with certain clients when, they're reaching out to family, friends. They're not, these people are, willing to give money, but they don't understand necessarily that down the line, whenever the debt converts, that they may actually be an owner of these, or financial interest holder, depending on what regulatory regime you're in. And then also, based on, depending on how the note, the debt works, you might not know what percentage ownership you'll hold in the future. And then depending on what state you're in, if you're above a certain threshold, yeah, you might have to go under a criminal background check. And I think for most people, that's something they're uncomfortable with. Kind of related to this, you see, venture capital funds, they kind of expect to maybe get a director put onto the board of the companies. And again, directors have to be disclosed on the licensing applications, and it's something that they're not necessarily taking consideration when they're asking for these things up front. So it's something that, both sides need to understand the implications of.
Yeah, so I very seldom recommend safes at the early stage. I'm not a fan of them for two reasons I want to talk about. One is, to Patrick's point, they are not simple. It is a complete lie. And actually tying it back to Adam's point earlier when he was talking about shareholder disputes, people in the industry, kind of minority investors going after, the larger holders, saying, well, we own this, we're entitled to these rights. The biggest mess you can get into is when all of the collective members or shareholders don't understand the documents that they entered into, giving them equity and or debt. And with safes, Patrick talked about the discount versus the valuation cap. The way these safes are drafted, and you can pull them off. You can pull the form off of the Y Combinator website, right? And so what a lot of early stage companies do is they say, oh, this is a simple agreement. Here's a form. We don't need lawyers. Just fill in your name, put in a number. We give you X%. But these terms about what you get at the next round, whether it's the discount or the valuation cap, they're very circular, right? So the idea of the valuation cap ostensibly is that, you know, let's say it's a $10 million valuation cap and you put in 1 million, right? So you're entitled to 10% presumably, but if it goes above 10 million, you're still entitled to that 10%, right? You have to be very careful with the language in the actual safes. I've seen a number of safes, even by the form itself, that really don't get you where you want to be just because of the way the formula is drafted. So there's just a lot of complexity, and I think that a lot of early stage investors and issuers, especially ones who don't get counsel involved, really don't understand what they're granting, what their rights are. So that's one of my concerns. The other one is, you know, as you get into later stages of equity raising, you want a clean capitalization table. You want your later investors to look at your company and be able to tell in one Excel sheet who owns what, right? And with safes, it's a little bit harder to do that, especially when you have, as is not uncommon in this industry, an early stage operator looking for 10 grand here, 5 grand there, who just hands out a bunch of safes to 20, 25 people, some of whom completely fall off the face of the earth, others who are very actively involved. And you have to capture that. You have to capture that in a very detailed capitalization table if you have sort of any chance of landing a sophisticated institutional investor down the road.
Yeah, I think there's a there's a really good practice point in there, which is for the practitioners in the room, if to the extent you can, and I know you can't be in the executive suite with your clients at all times, but when you can try to rein in the impulse of clients to save money by doing it themselves and pulling down one form of safe off the internet and selling it on a Monday, selling a different form on a Wednesday that has a different cap or a different discount, and then the next week trying to sell a safe to an investor, but the investor says, no, I want a convertible note, and then selling a convertible note. I've seen this. And it just, to Ilya's point, when that more serious Series A investor comes in and says, I'm going to put in $5 million into your terrific company, and you have to explain to that investor that, well, I've got a $200,000, flavor X safe and a $250,000 flavor Y safe and a convertible note, and they all need to interact together to convert into the round that you're leading. It's a nightmare. It usually works out, but it works out very expensively, and it takes, a lot of headaches. And it could, in the worst case scenario, crater a deal.
Yeah, and a lot of times too, we might get called into a company that's been operating or is in the process of obtaining a license for a couple of years, and they've gone through a number of these different kind of hodgepodge methodologies in order to fund their initial operations. And sometimes we look at these things, and unfortunately, it costs a lot more money for the professionals to undo all of what has been done originally to get the real funding mechanisms in there that are going to be the long-term funding mechanisms. So certainly, as we always say, kind of get people involved and professional services involved early and often in these companies.
I've seen way too many LegalZoom and Rocket Lawyer created documents for my clients, honestly.
And TurboTax, I actually have seen that too. That's scary.
And by the way, I've also seen, Patrick, I don't know if you've seen this as well, equity deals that just aren't papered at all, right? You see someone on an application say, oh, here's an owner of the company. He gave us $20,000 4 years ago. He's entitled to a 2% stake. No other documentation, just indication on an application. So down the road, when this company's seeking capital or even a sale, what do? You have ostensibly this equity holder who's entitled to part of the proceeds of the sale, but are they? That's a serious legal question that hopefully doesn't result in litigation, but very, very easily can.
Thank you, panel. So any litigators in the room? Anyone with a litigation practice here? Okay, it's fine, great. So this is a great practice. I hate to say it, but it's just true. We are seeing more and more, Ilya mentioned it, these, people, everyone thinking they have equity in a company, nothing is papered. You have a various level of kind of operators in terms of their sophistication of raising capital. And I was asked as a corporate attorney, so I'm going to this isn't a prepared question, but I want to put some of you on the spot here. because we are seeing a lot of business disputes, and I think primarily we're seeing those, shareholder breakdowns or, a lot of issues with people not actually understanding as a company grows, how many licenses they have, for example, or what are the interests in the licenses. I mean, it's amazing. We work with some companies, big companies, that are so busy out there, going out there to buying that they're actually not aware of everything they're requiring. So I'm going to ask a diligence question, but that'll be later. I want to ask the panelists, as the kind of the first people sometimes dealing with cannabis clients, what things can you do to mitigate that kind of risk of litigation and maybe regulatory risk as well? So it's kind of a two-part question, and I'll leave it to any panelists. If you got, let's just say you have a startup, they got a license, they're looking to raise money, whatever scenario you're facing. I mean, just if you could break down maybe a few things that would help to mitigate that kind of risk.
I can jump in because I'm also a certified fraud examiner. So I also do fraud and forensics along with cannabis. So the two have certainly come together, which has been a very interesting practice area for me to have the two come together. A lot of times when I have shareholder disputes, the biggest issue is that the legal documents were never finalized. They might have been drafted and they've never been executed. So oftentimes, there's just a lack of legal documentation to kind of point back to who owns what or how the capitalization table should have actually been established from the beginning and never was. Oftentimes that, if we're picking up a client, it might be that it doesn't even correlate to the tax return that was filed. So now you have all these different pieces of evidence that point to pretty much a big mess. And so a lot of work I do is in mediation between shareholders in terms of, how are we actually going to get to a resolution on this? Because a lot of times too, it all deals with numbers. So we also do a lot of valuation work in the cannabis space. So that's another instance where you have people coming on board, and if you don't have proper valuation of what people are receiving in terms of share compensation and things like that, in different waterfall provisions in the cap tables when people are looking to sell, everything needs to be spelled out completely and succinctly as possible and cleaned up. If you run into a client issue, I think, where there's all of those hodgepodge financing from the beginning, as an attorney, we kind of look to you guys to say, okay, from a legal perspective, this thing needs to be cleaned up, or else we can see where we're going to have to trace through and come up with numbers to try to support one side or the other if this goes to litigation.
Yeah, and this is, as a securities attorney, this is where I'll talk about disclosure obligations, right? I think one of the best ways, the best way to avoid securities litigation is to comply with securities laws, obviously. And, on a very kind of broad level, as many of you may know, anytime you issue stock or debt, right, it's a security. And if it's not publicly registered with the SEC, you have to find an applicable exemption, right? Most typically, the exemptions that are used kind of in the early stage private capital raising rounds is Reg D, Regulation D, which is, I won't go into too much of the nuance, but largely is to accredited investors, right? So if you have accredited investors, if you either get them to fill out an accredited investor questionnaire, if you're doing a 506B, or you might have to do some verification of their accreditation through a 506C, but that is a key way to protect, against securities law violations, right? Is having sophisticated investors who know what they're doing, who can make the appropriate reps. If you do not have accredited investors, right, and if you're relying on Rule 506, even if you have one unaccredited investor, your disclosure obligations are enormous. To follow the letter of the law, you effectively have to have audited financials, whole description of the business. And one of the key areas where I foresee litigation down the road, and it's already actually there, is with a lot of these public companies in their, disclosure statements, their annual filings, their quarterly filings, their press releases, right? They talk about, we won this license. We expect to open 3 stores in 2020, right? Anytime you make a statement like that, if it doesn't come to fruition, someone will come after you if, your stock is in the tank. So, I don't know if this directly addresses your question, but I think from a litigation standpoint and from a enforcement risk standpoint, one of the most important things you can do as an operator is talk to an attorney and say, hey, I'm raising capital. What is my exemption under the securities laws? what do I need to provide my investors in terms of disclosure?
Just to kind of reiterate a bunch of the points that have already been made, I think you got to bring in the professionals early on, start documenting everything, and then to one of Ilya's points too, is you got to make sure everyone understands exactly what they're signing on to. Just like the sophistication on both sides, the clients and the investors varies a lot, and some people get it right away. Other people, you really need to like hold their hand and walk through it and make sure they understand exactly what they're issuing. And to Mitzi's point too, it's like we have clients come to us with kind of half-baked companies, and you can't be afraid to kind of redo things. We have clients come all the time with LLC agreements because that they've used another company that they basically just Control F, replace the name, and then gave it to us. And maybe that works, but most of the time it doesn't, because it doesn't necessarily address all the regulatory issues that you need to include in an LLC agreement or bylaws for a license holding entity. And so a lot of times we have to take their operating agreement and amend it and restate it, and then basically kind of reset and go from there.
A lot of these corporate hygiene issues they're sort of industry agnostic, but I think in the cannabis industry where it's so new, and maybe the investors that we're dealing with, when you're negotiating a venture capital deal, it's actually really good to have a really good lawyer on the other side, irrespective of which side you're representing. If you're company counsel, that I love to see Wilmer Hale come up on the other side, because the stuff that they're going to send you is going to be good. The questions are going to be rational. You're not going to spend a lot of time explaining why a certain request makes no sense, et cetera, et cetera. Same thing when you're representing investors. You'd like to see a really solid counsel on the other side who knows what they're doing. So the corporate hygiene issues are obviously there. And to Ilya's point about the federal securities laws, we've also got this state law overlay that applies to all industries and all private offerings. And I think, Ilya, you probably know more about this than I do, but we've seen in Massachusetts, the Massachusetts security regulators have issued a statement that they are really going to put every single private placement by a cannabis company under a microscope. And companies have gotten nailed for it. They've been required to offer rescission to their investors because they were, these aren't, the case that I'm thinking of, it's not like somebody tripped up and missed the filing deadline by 3 days. It was, they were really actively flouting the law, some of the requirements that Ilya was mentioning. So you have to be doubly careful, I think, about all those sort of industry agnostic corporate hygiene things. But there's a couple other things that, we're working in an industry here that is a lot more complicated because of the regulatory overlay and because of the tax nuances. So there are some things that should go into your documents that may not be in your documents that you might use to raise a round of capital for somebody's building an iPhone app in their basement or whatever. To the extent that you're selling a large stake in your company to an investor, that investor should agree that if that investor ever becomes subject to regulatory, I defer to the regulatory lawyers here, but if the regulators ever tell your investor, hey, you can't own a cannabis license because of this crime you committed.
Suitability standard.
Suitability standard, thank you. Your documents need to say that if you as the investor become subject to an adverse suitability determination, we need to be able to buy your stock back, because that's going to crater the company.
Yeah, no, those are great points. And I would just say, for folks in here, regulatory is so key. And I'm sure you're consulting with regulatory at Foley. And, I'm really a regulatory attorney, but, we're talking to corporate folks all the time. And we're happy because our corporate attorneys are pretty well versed in a lot of the state regulatory aspects. But it's super important. Anytime there's any change to your structure or anything really related on the corporate side, that's probably going to translate into a reporting requirement, potentially approval requirement from state regulators. And we have seen in the industry a lot of companies, or I'll say several companies, stumble on this point, which is they're not keeping up with the state filings. And regulators, it's an easy one for them. If there's a regulation that says you can only control this many companies, well, you better stick to the letter of that regulation, because it's really an open book. They're administrative agencies, but they have a wide, it's fully transparent, and they have full subpoena power. And we see subpoenas get issued both by state regulators routinely And also, and questioning suitability, and even recently, there was a suitability case where the whole company kind of went down, the license, it wasn't because of one individual. So it kind of goes to Patrick's point of recommending having kind of broad, those broad clauses to allow, to get a buyout on suitability grounds. I want to talk about the securities for a moment. I know we're kind of running a little short on time, but we are seeing a lot of state subpoenas from the Secretary of the Commonwealth, as if we don't have enough regulatory hurdles in the Commonwealth. Now we have our Secretary of the Commonwealth really issuing a lot of subpoenas. We're seeing, there's a number of them out there. So Ilya, I don't know if you just maybe take 2 minutes to talk about what are they looking for, and what is the problem here at the state level, and why are we seeing so many subpoenas?
Sure. So the short answer is we don't know, and that's the problem, right? They're casting a very wide net, and as Patrick alluded to, there has been indication from the Securities, Enforcement Division of the Commonwealth that if you are doing a private placement in cannabis, you will get a subpoena for all of your offering documents and for information about all your investors. What we've seen in practice is subpoenas issued to entities that have done a capital raise, also entities who have not done a capital raise. Some entities that have received these subpoenas really don't know why they received them. Again, they have not raised capital, they have not signed definitive documents, and most of the responses to the interrogatories of these subpoenas is NA, right? Identify your investors. We don't have any, NA. And so this raises a lot of concerns because, first of all, where is the enforcement division finding these entities? Why is it choosing them for investigation? That's kind of the first one. The bigger one is a chilling effect on the industry, right? And I do think, to the extent that we, and our firm is constantly working with regulators and with state agencies, and we like to pride ourselves as being very involved in the industry on a kind of business level as well. So we try and work through these issues, and one of the things we're trying to understand is, if you as a regulator say, hey, any cannabis entity that raises money will have to provide us 50-page interrogatories and documents and information on your investors, we're ethically obliged to tell our client, look, if you raise money, you're probably going to get a subpoena, which will result in this much more legal cost, right? Your investors are going to be under stricter scrutiny. They might be brought in for questions. They might have to provide documents. And obviously, we can never advise our clients not to comply with law. So we always have to tell our clients, if you do a raise, you have to file these notice filings, these blue sky filings, right? All these securities obligations. So it is absolutely inevitable that if these subpoenas continue on this blanket level, that companies will say, to hell with it. It's not worth it. My investors don't want to be subject to this scrutiny. We're just not going to move forward with these raises. So I think, I just think it's a very serious obstacle right now in the space. And I don't think that the regulators in the Securities Division really understand the effect that these subpoenas are having. So yes, if you're an operator in the space, just know right now that, you will likely have to provide a number of responses and disclosures on top of what you have to do by law as a result of these subpoenas.
It's kind of a catch-22 situation right now because a lot of these subpoenas seem to be getting triggered by the blue sky filings we're making in the Commonwealth. So, we're trying to have our clients comply with securities laws, and that in turn all of a sudden gets them subject to a subpoena. So I know not every client necessarily does the blue sky filings. I mean, we obviously can't advise against that, but seemingly in this case, if you don't do a blue sky filing and they find out you did an offering, you're getting a subpoena. If you do an offering and you do blue sky filings, you're probably getting a subpoena. So yeah, it's not a good situation right now.
Great. So I just want to see if folks have questions. We have about 15 minutes left. I've still got a few questions, but does anyone have any questions out here they want to hit in terms of anything related to kind of subject matter?
How you doing? I noticed that the globe did an expose on cannabis industry gobbling up other businesses, basically being bought out after they get licensed, running them under shell companies so they don't violate the three license facility. They've also put out a request for proposal to have investigators dig into the finances of these corporations to make sure that they are only holding these things. Could this be behind this trend to send out all these subpoenas? Because the timing seemed to be consistent.
It's hard to know. I'm always amazed at how, I'm going to answer that question. I'm sorry,
Yeah.
panelists, because one of the panelists take it, but I have strong feelings about this Globe article. For people in the room that know me, know that I do. I'll say this, I want to defer to the panelists. The regulators in the Commonwealth are very, very reactive to what the media does. This is a natural tendency. We don't see it quite as pronounced in other states. They seem to be like, look, media, you might not have gotten this completely right. And that's actually, I think, the case with the Globe article. I think there was a lot there. And one of the problems with these companies is they're so complicated. And when you have complicated corporate structures, it just kind of raises a red flag for regulators because they're like, why would you set that up? Because they may not necessarily understand that there might be a business reason. Sometimes, honestly, we've had attorneys that were successor counsel, and attorneys just were like, what were they doing before? They were so happy setting up all these different business entities really for no purpose, and that creates real regulatory headache. But I want to defer to the panelists on the Globe question.
So I do think that is absolutely tied to the subpoenas. I also think that this is politics, right? To put it bluntly, if you followed some of the debates going on nationally about legalization of marijuana, you'll hear the phrase social equity, right? Criminal justice reform, social equity applicants. And in a number of states, Massachusetts, California, there is a priority that is being placed on issuing licenses to, previously criminally convicted individuals, people from, areas of disproportionate impact, as a way to make amends for, and rightly so, by the way, I mean, not to get into politics here, but obviously the victims of the drug war typically tend to be low-income minority individuals. The problem is when you structure a regulatory framework that is meant to empower social equity applicants, what happens a lot of time is you do have for political purposes, you have agencies and politicians scrutinize these deals to make sure that, you really are giving this in the benefit of your social equity partners, right? That this isn't just a way for capitalized entities to circumvent these requirements. And look, at the end of the day, well-capitalized companies are the ones who have the money to form entities and apply for licenses. And so it's not necessarily a sinister tactic for an MSO to partner with a social equity applicant and form a joint venture, but it doesn't look that way. And if you have, and this is the last thing I'll say about this, but if you have commercially reasonable terms, right, which perhaps that Globe article reflected arrangements which in any other industry would be very reasonable, right? Like a loan agreement that has a cash flow sweep, for example. There's a lot of risk in giving debt out to a cannabis entity, right? It's a reasonable term, it's arm's length negotiated, but it looks like you're taking advantage of your partner, right? And so I think, to answer your question, I think that the media mixed with kind of the political messaging around legalization is creating an easy environment for regulators to go after larger players or well-capitalized players for political gain.
Well, I think to that point too, I mean, it's very reactionary, right? So, I mean, what's going to happen after, last Friday in Fall River, right? So now we're going to see, what's going to happen out of the regulations that might come forth from there. And there's just so many different issues that we see, to Ilya's point, when you talk about how there are business reasons for certain, certain agreements that you might enter into for a certain business purpose. But I think that the social equity piece is really a tough piece that people want to have. And I remember talking to Shalene Title, and I was on a speaking engagement with her, and offline I said, how do you think this is really going to be able to roll out? Because I don't see it from a business perspective in a very highly regulated and difficult industry to deal with that also requires, some large amounts of capitalization, and there's no loan funding mechanism to really bring money to the table other than the bigger players. So how is this really going to happen? And I think that there is a concern that the regulators need to understand if, the intent of question 4 was to allow for repatriations essentially for past, drug history problems, that how is this really going to dovetail with a small business owner in Massachusetts? And I think the issue is as the market matures and you have more players there's over 400 licenses in the queue. So as those licenses get out there, all of a sudden you're not going to be able to survive as a small business before long. And that's why you have the consolidation and you have all of that, because you just physically can't be in business if you can't afford the compliance regulations associated with this business.
Any-
I think I have a question for Mitzi.
Oh, look at that.
After all these lawyers have done a good job creating a corporate structure and doing the financing and raising all kinds of capital for various instruments, now your cannabis business has all this cash because you've been successful. So how do you manage the cash? How do you find a bank, a Bank of America to issue you a bank account or a line of credit?
Yes.
Or factor your receivables, or do your payroll, or buy or lease your facility.
Yeah.
Knowing that all your expenses are not deductible because federally, the IRS laws, those are not deductible.
Yeah.
How do you get into cost of goods sold?
I mean, all of those issues are issues that the cannabis businesses face every single day. You know, with regard to banking, there are banks, state-chartered banks, credit unions that will bank the industry. So they just follow the DOJ guidelines. You know, they're going back to the Cole Memorandum, and they're kind of just working back with that and just following their guidelines by which they follow their Bank Secrecy Act requirements, their anti-money laundering requirements, and they can bank the industry. So there certainly are banks in the industry.
So I can go to Bank of America.
Not Bank of America. No, never Bank of America. Forget Bank of America. Cross that word out, or that whole, yeah. No,
Put it to a bank account there in Hartford.
they will never do it, I'm sure. You know, but Bank of America would be,
Basic, once I get all this money,
yeah. Well,
how do I manage it? Do I have to get
mean-
the cash, keep it under my mattress?
Well, the funny thing is, you know, surprisingly enough, with all of the funds that go into these businesses, most of it goes right out the door. So these businesses don't necessarily operate, except for the first, you know, dispensaries coming online in Massachusetts who are bringing in plenty of revenue to begin with. You know, a lot of these businesses operate with cash flow that's, you know, there's a lot coming in, there's a lot going out in order to pay off either, you know, debt, interest payments, things like that of initial funding. So they're operating like any other business. They just have to find the right players in the industry. There are payroll companies that will handle their payroll accounts. There are bank accounts that will, you know, that will handle their bank accounts in the industry. They just face unique challenges, but it's not insurmountable. But again, that's another barrier and a hurdle to a small business owner trying to just get into this business, and why many of those will also fail.
So which bank should I go to?
You've got Century, you've got Bay Coast, you've got GFA, you've got Safe Harbor. So there's a number of banks. Bristol County Savings is getting into it. So there's more banks that are coming online. I actually do speaking regularly to you know, bank directors and VPs and their compliance officers just of what the risks are, because they may not want to admit it, but cannabis money is already flowing through their banks. So they better have a program and a compliance program in place.
Yeah, hi. I'm with the American Arbitration Association, and I know that you didn't get to the arbitration segment there, but we are starting to see disputes among shareholders of cannabis cases trickle in, and with the experience of our Denver office, I expect we're going to start seeing vendor and licensing and all kinds of other disputes. So I don't know if you're going to, doesn't look like you're going to have time to talk about it, but I would just encourage anyone who's putting arbitration provisions in their contract to also talk to their litigators, because they're the ones who are gonna have to litigate the clause, the arbitration provision that you draft. And no offense to the corporate guys, but sometimes they're not the best drafters of arbitration clauses. There are also lots of tools available from the AAA, and a number of our for-profit competitors have lots of tools that you can use to draft a good clause, because that can be really key when you're drafting.
And kind of just to add a little bit to that, I know that, you know, people put in arbitration clauses, certain arbitration entities, and you really have to check to make sure that the entity you pick actually is willing to arbitrate a cannabis contract dispute, because there's many out there that won't. And so it's, you know, one thing you need to double check before you actually identify a particular association in there.
Yeah, and I did have that on my list. I appreciate bringing it up. Do folks want to have any insight into arbitration? I mean, we are seeing more and more commercial contracts have arbitration clauses in them. It's like the LLC versus corporation question. You know, what's the best answer? I think one of the reasons that we're seeing that is the confidentiality aspects. They tend to be more confidential. And these disputes tend to get picked up by the media, any litigation, especially if you're representing kind of a rising star in the cannabis space. Do folks, is that what you're seeing in your corporate practice, leaning towards arbitration? Anybody?
Well, I think typically people like prefer to go to arbitration just because there's still the question of whether or not, you know, a cannabis contract, at least in certain jurisdictions, is actually enforceable. And so the last thing you want to do is actually go to the court and then have the judge say this is an unenforceable contract, and then, you know, kind of both parties are out of luck there. So, you know, the preferred kind of route is to avoid litigation, and, you know, one of the best ways to do that is to kind of have arbitration clauses in there.
Yeah, I mean, I think in some instances, you know, I've been hired as a neutral by both parties, really to come in as the financial person and say, look, this is what we're trying to get to. Let's get to a number and let's settle this. And it's not even going through arbitration. It's not going through mediation. It's really, I'm sitting down with the attorneys and the shareholders in the same room, and they just want somebody who's able to kind of put a number to what they're talking about.
Any other questions? I think we're pretty good for time. I wanted to thank our panelists. It was a really awesome discussion around the corporate things. We're available for questions. The panelists will be available after, but I want to really thank our panelists. Really fantastic job.